Right now for resisting.
Resisting? I wasn't resisting.
You did resist.
No, sir, I did not.
When I told you to come in,
I did not resist.
Right, take him to the car, put him in the car.
Sir, I'm being detained. What am I being arrested for?
I just told you for.
What am I being arrested for?
I just told you.
Resisting.
In Florida, deputies responded to a residence after a 911 caller reported a physical altercation involving a man allegedly struck in the face with a beer can. What began as a battery investigation quickly escalated into a confrontation at the front door, where the subject inside the home refused to step outside and invoked his right to remain on private property. Within minutes, the man was taken to the ground, charged with resisting, and placed in the back of a patrol car, still asking what crime he had committed. This footage raises significant questions about the Fourth Amendment, Florida's resisting without violence statute, and the lawful scope of a deputy's authority at the threshold of a home. This footage was obtained through a public records request. The deputy arrives at the scene and is immediately flagged down by a neighbor, who identifies himself as the 911 caller. The neighbor explains that he heard fighting from inside the home and witnessed a man emerge holding his face, alleging he had been struck with a beer can. Under Florida Statute Section 784.03, simple battery is defined as the actual and intentional touching or striking of another person against their will. A caller's eyewitness account, combined with a visible injury, can establish probable cause for a battery investigation, but the decision of who committed the battery remains an open question that the deputy must still investigate on scene.
Hey, come over here. What's going on? Hey, come here.
So, the sheriff's office, I called it in. I live right here. I hear him fighting. He comes out holding his face. He hit him in the face with a beer can. And then he came out recording, obviously, get off the property, blah, 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 blah.
Illegally enter the house.
So, there you go.
No, you hit me with a beer can. I don't even drink. No, it smells like beer.
All right,
So, yeah, believe me, I have beer.
what's going on? How do you live here?
No. Terry knows everything. The owner and him.
What are you doing over here?
I want to give a ride to the flea market.
Hey, step out here.
No, sir.
Step out here.
Sir, I will not. I am on private property.
I understand.
There's nothing wrong.
Step out
Get
here.
off the property.
Step out here.
Sir,
That's not going to happen.
off the property.
Sir,
You cannot enter this home illegally.
step out here.
Step out. I'm not.
We're not
Sir,
entering
I don't
illegally.
trust you, and that man that come over with the detective badge, he harassed me already.
Hey,
3 times.
Hey, step out
The
here.
house, dude.
Step out here.
Nothing going on. I don't trust you. I've already been.
I don't care if you trust me. Step out here. You have no reason not to trust me. You got a way to enter this house?
I just tried.
Dude, I'll open the door, but you ain't grabbing me.
Then step
No,
out here.
sir, I am not.
Step out
This
here
is
and talk to
private
me.
property.
I don't care.
Talk to me right now. I'm
No,
recording.
step out here.
No, sir.
Okay, then I'm coming in.
No, sir, you're not.
Then you're stepping out here.
No, sir. You're
All right.
forcing your way up. I'm being recorded, dude.
Step
You're coming
out
in the
here.
house.
Step
Fine,
out
I'll
here.
step out, dude. Easy.
Step out here.
Just ease up, dude.
Step
Ease
out
up,
here.
bro.
Step
Ease
out
up.
here. Listen, I ain't playing this
Ease
game.
up, man.
Shut
I'm
up.
stopping, dude.
Shut
I'm
up.
stopped.
We're not playing this game.
Fine. What did I
All
do?
right?
What crime
I'm
did I
telling you to
commit?
step out. A battery.
No, I didn't. He hit me. Look at my
Okay.
lip.
Well, that's what we're here to investigate.
Fine,
He's got a
thank
bloody
you, sir,
nose,
but
all right?
I've got a
But you're
bloody
not going
lip.
to shut the door on us when we're here
Excuse
to
me.
investigate a battery.
Excuse me, sir.
It's not going to happen.
Thank you, sir.
All right?
but,
Now step over
that's
here, calm
fine,
down,
sir.
and speak to me and stop
Fine,
yelling.
sir. Just let me get my
Stop
composure.
yelling.
Fine, sir.
And you're not going to walk away from me.
That's fine,
You're not
sir.
going back in the house.
I didn't do anything to you.
All right. Well,
Yes, sir,
we're
that's
here to
fine.
figure out a battery.
That's
We got
fine, sir.
accusations of a battery.
You see my
All right?
lip?
No, I don't see your lip.
Look at it.
All right.
He started it. He don't live here.
All right. Well, we're going to figure that out.
Fine, sir.
But you're not going to go back
That
in.
man
And you
across
can't
the
act
street-
like this.
Dude, either can that detective. He tried to force his way in this door, and he
Because
harassed
we
me
can if there's
sir.
batteries
If
occurred.
there's an
twice. Did
allegation of
he see
battery,
it? Did the detective
We're about
see
to
it?
find out.
I haven't been drinking. It's not like beer, though.
Who are you to them? Just
Friends,
friends?
yes.
All right. So what happened?
I come in the house, and you told me to get the hell out. You know, I was going to pick up Tara to go to the flea market.
Were you invited over here by her?
Tara, yes.
Does she live here?
He called me 10 times to pick her up today.
Does she live here?
Yes.
Okay, so what happened once you got here?
And then all of a sudden he told me to get the fuck out. And I said, I don't have to get out. It's her house. She invited me in.
Right.
And all of a sudden he started getting really pushy, and all of a sudden, get the fuck out of my house. It's not even his house. And he
Okay.
had a beer. I said, fuck you. And I cursed back at him.
Okay, so
And
then
he,
what
he was
happened?
all him. And then he smashed the beer in my face.
Did you hit him?
No, I tried to block him.
Okay, but you never threw a punch
No.
and hit him? Okay. Do you need EMS to come look at your
No,
nose?
there's nothing. The only thing I'm pissed off is I smell like beer.
All right.
And I quit drinking and it makes me want to
So,
drink.
do you want to file for charges on him, or what do you want to do?
I don't want. I think they should cover it.
Who should cover it?
No, it's her house. She's looking for a scapegoat to take her. I don't want to take care of this.
Okay.
I like the guy. It's just so his medicines.
You have to tell us if you want to file charges or not. I mean, it's up to you.
I'd rather not.
You'd rather not? All right. So you want to write a statement or anything like that?
Just what they see, man.
Who?
I'm not going to file a statement. I'll file. No.
The deputy approaches the open doorway and encounters the subject, who is actively recording on his phone. The subject immediately invokes his location on private property and refuses to step outside. The deputy responds with repeated commands to step out. Under the Fourth Amendment, in the Supreme Court's decision in Payton versus New York from 1980, the threshold of a home marks the boundary of heightened constitutional protection. Absent consent, exigent circumstances, or a warrant, officers generally cannot cross that threshold to make a warrantless arrest. However, the analysis shifts when officers have probable cause and the suspect is standing in the doorway itself, an area the courts have sometimes treated as a public place for arrest purposes. This doctrinal tension defines the entire encounter. As the verbal exchange continues, the deputy warns that he will enter the home. The subject finally agrees to step outside, stating, "Fine, I'll step out." What follows is the critical moment. The deputy takes physical control of the subject the instant he crosses the threshold, and the subject pulls away, stating he is being recorded and asking the deputy to ease up. Under Graham versus Connor from 1989, any use of force by law enforcement must be objectively reasonable under the totality of the circumstances, judged from the perspective of a reasonable officer on the scene. The relevant factors include the severity of the crime, whether the suspect poses an immediate threat, and whether the suspect is actively resisting or attempting to flee. A simple battery investigation without an articulated threat places this encounter on the lower end of that spectrum. Florida Statute Section 843.02 criminalizes resisting, obstructing, or opposing an officer in the lawful execution of any legal duty without offering or doing violence. The key phrase is lawful execution of any legal duty. Under long-standing Florida case law, including the Florida Supreme Court's decision in Tillman versus State from 2008, a conviction under this statute requires the state to prove that the officer was engaged in a lawful duty at the moment of the alleged resistance. If the underlying order or detention is unlawful, the statute does not apply. This single legal principle will determine whether the charge in this case can survive a motion to dismiss. While the subject is detained, the deputy speaks with the alleged victim, who describes being struck with a beer can, but states clearly and repeatedly that he does not wish to file charges. In Florida, a battery is a crime against the state, not the individual, which means the prosecutor, not the victim, ultimately decides whether to file charges. However, a victim's refusal to cooperate is a substantial factor that frequently results in the state declining to pursue charges. More importantly for this analysis, the deputy has now confirmed that the original probable cause for battery is weakening. The alleged victim is not pressing charges, he does not want the subject arrested, and he attributes the incident to a medication issue rather than criminal intent.
So, did somebody mention something about a BB gun or anything like that?
I don't know about that at all. I come over here to bring water over and
Okay.
stuff like that. I was full of fun.
All right, so you usually get along with him?
Yeah, most of the time.
So what's his issue today with you?
I think he didn't take his medicine.
So,
Oh my God.
it's up to you. Like I said, if you want to file charges, it's totally up to you. If you file charges, he goes to jail. If you don't, he don't go to jail.
I'm
So,
not gonna go. I'm not gonna file charges.
okay.
It's just I don't want to be the scapegoat. You come out of jail and I'll be the one. And you gotta go to court. They called the police at least 10 times on him.
Well, we're still going to document it and everything, so the report's still going to be written. But, you know, if you don't want to file charges, then we're not taking him to jail or nothing. So.
Because I don't think they call the police on each other 10 times a week. I come over, give him water, and stuff, and
Gotcha.
try to help. This guy knows. Get him over there.
All
I
right.
try to do the right thing in life, but hey, all I came to give her right to the flea market. You showed my phone. She called me like 8 times today.
All right.
I want to go to the flea market because I came over.
Oh, it's constant. So I got a video yesterday where he acted like he was going to hit me in the back with a bucket when I was getting something out of my truck because they've been stealing water and shit from his house.
Yeah.
And I was getting keys out of my truck, and I have a camera on that tree over there. And I'm in my truck, and he's got this bucket in his hand. He's acting like he's going to walk up and hit me with this bucket, and then he starts cussing me. He's like, stupid MF for this and MF for that. And I was like, what?
Are you actually Leo or?
Oh, yeah, I work in narcotics.
Yeah,
Gotcha.
he's with Crown.
But no, this is an ongoing issue, and
You
I've
didn't,
come to the point of filing stalking charges on
You
him.
didn't want to file any charges for assault or anything?
Well, I would have loved to, but I didn't think about it at the time. I've thought about filing charges for stalking because he stood here and MF'd my wife and my 13-year-old daughter in the driveway, telling them to get the F back in their house.
Yeah.
And my mom.
And her mother. Like, it's uncalled for.
Right.
And he knows I'm the police.
Yeah.
And every time he sees me, he purposely goes out of his way to try and pick a fight.
Yeah, we've been here a couple times. Same, same situation. If it was me, I would want this guy to press charges, but he says he doesn't want
I told him
to. He needs to press charges.
that
But-
he doesn't want to get involved, and I was like, this isn't going to end then.
No. So you own the house, right?
Yes. He's got eviction papers to get out.
How much longer does he have on the eviction?
Probably another, like a week and a half.
A week and a half?
10, 12 days, yeah.
Okay. And so is he going to be gone at that point?
Yeah.
You have any idea where he's going?
I have no idea.
No. All right. Who is he to you?
He was dropped off here. So I don't know. I mean, he wasn't really told he could stay here. He just dropped off and he started staying day after day on the couch. And
Yeah, you can't let that
just
happen.
asked him to leave and it just won't happen.
But this is your place, right?
Right.
Yeah. You can't let that happen. If you let somebody move in here, then you have to go through this whole process. But next time, don't let people just, if they get dropped off here, then you have the right not to let them in your house.
Right. Now he's already in.
Doesn't matter.
Yeah, she was actually not, it wasn't like that.
So he was an invited guest by somebody else that was living here?
No. He just got dropped off and he needed a place to stay, I guess, and he just started staying on the couch. And
How do you know him, though? How did he know to
I
come
know
here?
him from the guy that drives this truck, Jack.
Okay. But yeah, you don't have to let anybody stay here. I don't care if they're dropped off or
I've
not.
asked him to leave many times and he won't leave. The police have been here and then he shuts the door and knocks him out and
Yeah.
he ends up staying anyway. So
So how long has he been here, though?
it's been going on like a couple months.
Yeah.
But he got his paperwork, so we'll see what happens.
So how long ago did he get the eviction?
Just a few days ago I gave it to him.
Okay. Was it 30 days? A 30-day
No, it's not
eviction?
been 30 days.
No, is it a
It was
30-day
15
eviction?
days, I think.
They gave him 15 days to move out?
Yeah.
Okay.
Or 15 days minus the weekends and holidays, something like that.
Gotcha. He's going to jail no matter what. We're taking him for resisting. He backed away from me, went into the house, pulled away from me. I got resisting charges. So
I didn't
he
really
also hit
happen.
the friend here too, I guess, when he was trying to break it up. Did he hit him as well?
He just said, think about it.
Let me go see if they're all right.
You got me. You know that. You hit me too.
The deputy then learns from the homeowner and a third party, who identifies himself as a narcotics officer with another agency, that this is an ongoing dispute involving a guest who has been staying on the couch for several months. The homeowner confirms that a formal eviction notice was served only days earlier, with approximately 10 to 12 days remaining on the notice period. This is a critical legal detail. Under Florida landlord-tenant law, once a person has established residency, even as an uninvited guest, they generally cannot be removed through a criminal trespass arrest alone. The proper remedy is civil eviction through the county court. This means that at the moment of the confrontation at the door, the subject was not a trespasser. The deputy could lawfully order out of the home. Despite the alleged victim declining to press battery charges, and despite the subject's apparent residency status, the deputy states on camera that the subject is going to jail regardless, charged only with resisting. He explains that the subject backed away and pulled away when ordered to step out of the home. This is the pivotal moment of the encounter. For a resisting without violence charge to stand, the deputy must have been engaged in the lawful execution of a legal duty at the time of the alleged resistance. If the order to step out of the home was itself unlawful because there was no warrant, no clear exigency, and the subject was a lawful resident, then the resistance to that order cannot be criminal under Florida law. In the back of the patrol vehicle, the subject asks repeatedly what he is being arrested for. The deputy answers each time with a single word: resisting. Under Miranda versus Arizona from 1966, a subject must be advised of their rights before any custodial interrogation. But Miranda does not require an officer to explain the charges at the moment of arrest. What Florida law does require, under statute section 901.16, is that when asked, the officer must inform the arrestee of the cause of arrest. The deputy here does comply with that minimal requirement, though the subject's continued confusion suggests the communication could have been clearer.
Thank you, sir. I'm being detained for what? What am I being detained for?
Right now for resisting.
Resisting? I
Yep.
wasn't resisting.
You did resist.
No, sir, I did not.
When I told you to come
I did not
All right,
resist.
take him to the car, put him in the
Excuse me,
car.
sir, I'm being detained. What am I being arrested for?
I just told you for.
What am I being arrested for?
I just told you.
Resisting?
Yeah.
Dude, ease up, bro. Let me walk. Let me walk, dude. Ease up. I'm on disability and you've heard me before. I'm going to jail for resisting arrest. That's what you said, okay?
Not resisting arrest.
For
Resisting.
what? Resisting arrest?
It's not
Dude, I was detained. You said I was detained. You put me in the fucking car, man. This is ridiculous.
Searching for you.
Go ahead, dude. There's only a wallet in my pocket. Jesus Christ.
Well, we have
man,
to search
I didn't
you.
do anything but protect myself.
No, you walked
Resisting
away and
arrest.
pulled away from. It's not a resisting arrest.
That's what
It's
you
resisting.
said. You detained me and you,
You
said
don't
it was
you-
for
you
resisting
don't stop
arrest
talking-
I'm being arrested for.
Listen, you don't stop talking long enough to
Well,
understand
dude,
what I'm telling you.
why are you muscling me then? I was detained, and now I'm
Yeah.
arrested for resisting arrest? Well, good, man. What's your name? Williams and who? Bro, I'm being arrested for what? What am I being arrested for?
That's upper.
Resisting what?
Hey, lap.
No, sir. What am I being arrested for?
That's fine.
What am I being arrested for, Rodriguez? What am I being arrested for, sir?
Rodriguez.
What?
Who's Rodriguez? Is that? Yeah, that feels profiling. Yeah, he called him Rodriguez. He called you Rodriguez.
The first and most important lesson is that the threshold of a home is a constitutional line that officers should not cross without a warrant, consent, or a clearly articulable exigency. The Supreme Court drew this line in Payton versus New York for a reason. The home is the place where Fourth Amendment protections are at their strongest. When an officer orders a lawful resident to step outside specifically so that an arrest can be effected at the doorway, courts may view that as an attempt to circumvent the warrant requirement. The proper approach, when there is no exigency, is to slow the encounter down, gather witness statements on the outside, and obtain a warrant if probable cause develops. The second lesson is that a resisting charge depends entirely on the lawfulness of the underlying order. Officers cannot bootstrap an unlawful command into a criminal charge simply because the subject refused to comply. Florida's Tillman decision makes this explicit, and similar rules apply in most states. When an officer's initial probable cause weakens, as it did here once the alleged victim declined to press charges, the answer is not to pivot to resisting as a fallback. That approach creates the appearance of outcome-driven policing, exposes the agency to civil liability under Section 1983, and places the charge on legal ground that a defense attorney can attack through a motion to dismiss. The third lesson is that residency disputes are civil matters, not criminal ones. A person who has been living in a home for several months, who has received a formal eviction notice with time still running on it, is a tenant at sufferance under Florida law. They cannot be removed through a criminal trespass arrest, and they cannot be ordered out of the home at the command of a responding deputy. The proper remedy is a civil eviction proceeding in county court where a judge issues a writ of possession and the sheriff enforces it on a fixed date. Officers who treat long-term guests as trespassers risk false arrest claims and undermine the civil court process that exists precisely to handle these disputes. The fourth lesson is for the citizen. Knowing your rights is valuable, but asserting them calmly and in writing protects you far better than arguing at the door. The subject in this case was correct on the law. He was on private property, he was lawfully inside a home where he resided, and he had no obligation to step outside on a vague command. But by pulling away physically, he handed the deputy a factual basis for a resisting allegation that will now have to be litigated in court. A better approach is to state the objection clearly, comply with physical instructions under protest, and preserve the legal fight for a courtroom where it belongs. The final lesson is that every body cam recording is evidence for both sides. The deputy's own footage in this case documents the victim declining to press charges, documents the eviction notice still in progress, and documents the deputy stating on camera that the subject is going to jail, regardless of what the investigation reveals. In an era of mandatory body-worn cameras, both officers and citizens should assume that every statement, every command, and every moment of hesitation is being preserved for later review. That reality changes how professionals on both sides of an encounter should conduct themselves. Let us know in the comments whether this arrest was lawful, whether the deputy should have stepped back and sought a warrant, and whether the resisting charge can survive legal scrutiny. Thank you for watching 48 Hours Solves Cases. Don't forget to check out our second channel for more police interaction and courtroom analysis.